Joan, just like yesterday, you were in the court. You were in the court again today as these final major decisions were coming down. Take us inside the court and tell us what you saw.
Sure, and I didn't mean to sound so breathless, but it did just end a few minutes ago, and I got zipped over here. Again, this time it went for more than an hour, and what was interesting, and I'll start with the ruling in the religious rights versus LGBTQ interests, because two very different portraits of the facts of the case and rights in America were drawn by two justices sitting right next to each other. You know, they're all arrayed up on the mahogany bench, and you had Justice Neil Gorsuch begin by talking about the religious rights at issue here for a woman who said her free speech was impinged because she felt like she would be forced to create a wedding website for same-sex couples. And what he stressed was that she was not going to discriminate against the couples based on their status. She wanted to foreclose that option based on the fact that she did not want to articulate speech. So everything that Justice Gorsuch drew out as he presented his side of the case, his winning side of the case, had to do with free speech. He talked about instances when the court had said that no, students could not be forced to say the Pledge of Allegiance or to salute the flag, and no, government could not stop the Nazis from marching in Skokie because that was part of their free speech rights. Everything that he referred to here, including a veterans parade that wanted to keep out banners and marchers who were going to tout gay rights. That's the kind of context he drew here. And in part to get ahead of what the dissenter, Sonia Sotomayor, sitting right next to him, was about to say, he reminded the audience sitting in the courtroom about the Bostock ruling that he had actually written back in 2020. And that was a case in which he was with the majority to expand LGBTQ rights in the workplace. So he wanted to carefully distinguish what was being precluded here. And then when it came time for Justice Sotomayor to speak on the part of the dissenters, only the three liberal justices, as I'm sure you've already laid out, she said, this case is not about speech, it's about conduct, and it's about status. It's about allowing a website designer to put out a sign to say same-sex couples need not come here. And she drew a contrast to all that Justice Gorsuch had laid out over several minutes as he opened the proceedings with detailing what the justices had done in this case by saying, look at how this fits into the history. And she also referred to the most recent history. She said, look at how much has changed in just 5 years when justices of this court, long gone now, Justice Kennedy she was referring to, said that retailers and businesses cannot exclude individuals just because of their status. And again, she was removing this case from the pure free speech realm that Justice Gorsuch was casting it and saying, if the court allows this kind of discrimination, blocks the public accommodation law that Colorado has, this could lead to other kinds of discrimination. And the cases she invoked all had to do with very serious discrimination, including one from way back when, before the civil rights era, in which I think it was Ollie's Barbecue, I know it was a barbecue stand, wouldn't serve black customers at tables, would only allow them to come to the window of the establishment. And she said, it's as if this Lori Smith in this case, who runs this 303 creative enterprise, will only sell at the side counter. So a very dramatic rendering and a very disparate rendering of what the facts of the case were and the law at issue. And the whole time that Justice Sotomayor was reading excerpts of her dissent, Neil Gorsuch, sitting right next to her, instead of just tilting his head toward her, as often happens, he looked straight at her, not flinching at all. And I'm sure he was, quite firm in what he believed and quite firm in the majority that he was able to get for this case, to side with this woman who, I should remind everyone, has not in any way been sanctioned by the state of Colorado, has not been found in any way to be not abiding by the state's public accommodations law, but who had brought this case as what's known as a pre-enforcement challenge. So in so many ways, this case was sort of created out of facts that don't quite fully exist yet. And that was another thing that Justice Sotomayor pointed up. And then, would you like me to go on? Should I go to the next case when the chief starts talking?
You're the one who was in the room.
Sarah.
You were the one who was there.
Okay, great.
You saw it.
Great.
You were there and you
You know,
felt it.
I just have to say, for this last day, you just saw all the tensions on so many issues. You know, this was a culture war issue that I just played out on, you know, same-sex couples versus a Christian owner of an establishment who just feels like she has a right, she has a free speech right not to adopt the message of a same-sex couple. It's all part of the culture wars. And just one quick PS on that. Justice Sotomayor, when she was talking about why this was so wrong, why the court was, in her words, profoundly wrong, she referred to the kind of discrimination that gays and lesbians face right now. And, you know, the kinds of, you know, movements we've seen in the states. She referred to state laws that are right now just being created across the country that could allow discrimination against gay rights. And she said, at this kind of time, what does the Supreme Court do? It shrinks back from duty to protect people and instead signals that these people's rights are not in need of protection. So I just to close out kind of the drama of that, and then to sort of point up the wide expanse of how this Supreme Court is affecting American life and the powers of government, Chief Justice John Roberts then is going to detail exactly why the Secretary of Education was wrong to try to provide loan forgiveness to millions of borrowers in the wake of COVID. And in that case, first of all, there was a real issue whether these 6 Republican states that had challenged this even had a right to do it. And he brushed back some concerns there about whether Missouri even could do it. He has such a brisk voice and tone that it was in contrast certainly to Justices Gorsuch and Sotomayor, but he just cut to the chase and said there was an injury here, there was legal standing on the part of the state of Missouri to bring this case, and then when he got to the nub of the whole thing, he said something that will have reverberations in so many areas of regulation and protections for people that government wants to protect, in environment, student loans, health, welfare. He said that the Secretary of Education went beyond what Congress would have wanted to do at all in this matter, as I'm sure has been spelled out by other legal analysts here. You know, the Secretary of Education, working under emergency provisions of this law, said that these student loans could be forgiven up to $20,000. And Justice Kagan then, in her dissent, said, look at what this court is doing. It's not quite reading the statute correctly. The chief has just picked out parts of the statute that suit the majority's interests and is not reading it as a whole. And she stressed the reverberations it would have in so many other areas of government regulation, government protection. And hers were the final words of the reading of the opinions that just talked about what a different court we have in America today. And then shortly after 11 a.m., Chief Justice John Roberts said, that's it for this term. And to paraphrase what dissenters said last year, I am sure this majority is not quite done with its work going forward, beginning in the fall.